My name's Jim Doyle, and I'm here today to speak to you on certain aspects of employment and related law. The particular topic that I want to speak on is restraint of trade clauses, their role in a relationship relating to a business, either with employees or with other companies or with subcontractors. What I'd like to do today is to take you through some general topics to set the context, and then to review three cases in detail. The historical context is important because it's important to see that the courts were the first influence to adjust the relationships between people so the public interest of free trade and competition could be enjoyed by all. The courts were concerned not to allow markets to be tied up by private contractual arrangements that were at odds with the public interest. The courts considered that everybody should be free to compete and free to contract with whoever they wish to contract with. The courts had developed the concept that that approach was likely to deliver the best reward to society from the developing technology and trade that was blossoming in the 1800s. However, that does have some impacts for today's relationships between employers and their resources. It's important to define what we mean by restraint of trade. The courts have defined it in one leading case of Nordenfeld, which is generally considered to be the start of our modern treatment of restraint of trade. The courts there looked to see that a restraint of trade would be fundamentally challengeable unless it was restricted to have a reduced scope. The terms to be protected should be a legitimate interest, that is, recognised by the court as having some legitimate right to the employer to restrain it. The terms had to be reasonable from the viewpoint of the parties involved, but also reasonable from the perspective of public policy. You'll understand that the courts dealt with certain aspects of restraint a lot more easily and more certainly than others. So the idea of misusing a patent was clearly able to be injuncted because there was a registration of the patent and therefore some clearly defined rights. On the other hand, the idea of know-how or ability to run a business was of such a vague definition that the courts were slow to protect it. So they're looking for legitimate interests, definable interests, and a reasonableness in the restraint. It is against that background that we come to look at the three cases that I want to deal with in detail today. The cases provide us with practical demonstration of how the court will approach the question of restraint of trade and the remedies available to an employer to protect his various interests. First is Comsport versus Mulligan and Miro. This was a case where there was a computer support company that had engaged two senior technicians who, after working for the company for a number of years, decided to go into business for themselves and gave their notice and proceeded to set up their business. They timed it so the proprietor of the business was away on holidays in Europe for a month, but that was just a sidelight. The restraint that was operative in that situation read as follows. The employee expressly agrees as follows: not at any time, either during or after the termination of the employment for any reason, and either on his own account or for any other person or any other firm or company, to solicit, interfere with, or endeavour to entice away from the employer any person, firm or company who at any time during the continuance of employment shall have been a customer or client of the employer. So that clause was a very wide restraint of trade, and the court looked at it carefully to see whether or not it was legitimate. Firstly, they looked at the roles of the executives in the company, and they distinguished between two different roles. One was a client-facing role which built up a relationship with the client, and the other was simply a back office role with little contact with the client. The courts saw as legitimate a restraint of the client relationship that had been generated during the employment, rather than a restraint of that same nature applying to a back office operative. There are other wide restraints of trade which attracted the attention of the court. The court relied on the Nordenfeld case, and the opening sentence of the extract that was quoted by the judge read as follows: "All interference with individual liberty of action in trading and all restraints of trade of themselves, if there is nothing more, are contrary to public policy and therefore void. That is the general rule. There are exceptions. Restraints of trade and interference with individual liberty of action may be justified by the special circumstances of a particular case. It is a sufficient justification, indeed it is the only justification, if the restriction is reasonable. Reasonable, that is, in reference to the interests of the parties concerned, and reasonable in reference to the interests of the public." Accordingly, a very tight and high barrier for restraint of trade is traditionally drawn. The judge went on to say that the restraint of trade must be directed towards a legitimate interest of the employer, recognised by the courts as being the subject of protection, and rather than restricting competition, it should be directed towards protecting the employer's legitimate concerns. The court recognised that the employer had a legitimate interest in stopping the employer who'd become the human face of the employer's business from competing with the employer after he left, because that would be in some ways unreasonable. Justice Brereton in Coop's Financials said that a more robust view could be taken when the employee's role includes obtaining and extending custom for the employer's business. Similarly, in HRX Holdings versus Pearson, Buchanan upheld a restraint against a former employee where he found that Mr. Pearson is regarded as having a very special ability to connect with prospective clients, gain their trust and convince them of the benefits of putting their business the employer's way. However, in the Queensland Supreme Court, in AGA Australia, Mr. Justice McMurdo said, "A restraint upon competition is not justified simply from a history of contact between the employee and the customers. There must be a relationship of a kind that would make it a contributing factor in a customer's decision to give its business to a competitor." So the courts have recognised that it's legitimate to keep and protect a relationship with a client, but they've also said that that must not restrain people who haven't had the opportunity to develop a particular relationship with the clients of the firm. One aspect that's important in considering the restraints of trade are that they are a contract, that is, a voluntary agreement between two parties, designed to give each the benefits of the agreement and to burden each party with the obligations. However, the courts have traditionally regarded the employee-employer relationship as not being one of equal bargaining, and courts have said that at the highest level, at the High Court, that little weight is to be attached to the consensual nature of the restraint. That is, the voluntary nature of the agreement doesn't really carry much weight when it later comes to be tested. The further aspect of the restraint that should be looked at carefully is the width of the restraint. The width in both the parties that it applies to, the length of time that it continues for, and the extent of contact that it prevents. For instance, it is one thing to say one must not solicit or go and seek business, but it's another one to say if business comes your way, you're not able to accept it. Again, if the restraint is applied to all clients of the firm rather than a particular subset with which that particular employee has dealt, then the wider restraint is likely to be challenged successfully. So it's important when drawing restraint of trade clauses that one looks to a reasonable approach, both from its time of operation and the extent to which it impinges on the future trading capacity of the ex-employee. An important aspect of the case was the degree to which the employer had to prove the breaches that had been carried out by the ex-employee. He had to actually find customers who'd been approached and refused the ex-employee's offer of business, and he had to find those customers who had acceded to the representations and invitations of the ex-employee in order that he can prove that the ex-employee was actually actively soliciting business. In dealing with those customers, the judge was keen to observe whether or not those customers would have shifted from the business of the employer in any event, or whether they were actually induced by the employee. The individual circumstances of each customer was explored, and of course there would have been a great amount of cost for the employer to prove that the approaches had been made. The next aspect that came up was what were the damages. And in this situation, the damages were conceded by the court that they can be difficult to calculate. The issue of a loss of business or a loss of trade claim, if you have access to your hamburger shop completely prevented, is simple. You provide your trading figures the month before, your trading figures during the interruption, your trading figures after. That might suffice to prove that loss was suffered was total. However, where you have an ex-employee advertising to your customers, it's hard to prove what effect that'll have. Conceptually, it could mean that he would attract some customers. He might also dislodge some customers and ask them to reconsider their position, leaving them to go to other firms. And alternatively, it might reduce the amount of business they give the employer. The proof of that, where it only affects a subset of your customers, is very difficult. The courts then are happy to accept the difficulty of calculating damages, but they also impose on the plaintiff the onus to prove the loss, so that where it is possible that proof is presented, it must be presented in a cogent way in order to attract an award of damages. This is a substantial burden on an ex-employer, because the degree of disruption to his business, the degree to disruption to his relationships with his customers is substantial, and at the end of it all, he might only be able to prove a fraction of the loss he's suffered and recover only a fraction of the damage done. The court is at pains to understand that there is a chance the business would have been lost in any event, and accordingly the court is prepared to put a discounting factor on the damages, due to the chance that the customer would have left the business in any event, perhaps at the end of the restraint period, perhaps at some period afterwards. The court investigated various methods of trying to calculate the loss, a discounted cash flow or a valuation of the ultimate amount that might be obtained from the customers. However, the position was that that would involve a conjecture as to how long they'd stay with the firm, and that inevitably led to a substantial deduction in damages. The end result of that case was that the restraint was considered too wide, the reward and remedy requested was refused, and costs were awarded against the plaintiff. So the ex-employer ended up with an expensive legal bill of his own, together with the legal costs or a substantial portion of the defendants, and no recovery for the damage done by the employees. It requires then to look at that case in detail to see, when you're doing a restraint of trade clause, that it is fair, it is reasonable, and it is effective in establishing a legitimate degree of protection to the employee's rights. This case demonstrates some of the limitations that the law imposes on an employer's ability to restrict the future activities of his employees. The law looks for a very reasonable, quite narrow restraint of trade, such that it allows the employee to use his skills to earn a living going forward. The employer must be careful to ensure, when drawing restraint of trade clauses, to ensure that they're reasonable, they're fair, and that they will allow him some reasonable protection for his legitimate interests. The second case I need to address is Quantum Service and Logistics versus Schenker Australia Proprietary Limited, which was a case in the New South Wales Supreme Court, which considered the issue between two effectively joint venturers. Two companies had combined together to provide a service to a third company. Because of the combination, they had agreed not to poach each other's employees. That meant they could work more closely together and be confident that their various know-how and expertise wouldn't be poached by the other. The issue came up when an employee wanted to transfer from the subcontractor in the arrangement to the contractor, and the subcontractor objected and took prompt action to obtain an injunction to stop the contractor employing his ex-employee. The matter came on very quickly, where the court heard the application for an injunction that very day, continued it to the next day, and then the court continued it for a further week while the parties put their evidence on, and the court could then consider it at some length. The court had to consider what was a reasonable protection between the two companies. They decided that the approach of the court was more liberal, where two companies were contracting to restrain their trading activities, than it was between an employee and employer. No doubt that attitude is affected by the court's approach to an employer-employee relationship being one where there is an imbalance of negotiating position. The courts are more likely to assume that two independent companies are more at arm's length and more equally balanced. However, the issue is that it's not only the relationship between the two parties to the restraint of trade, it is also its impact on the public and in this case its impact on the employee who was the victim of the restraint, in the sense that if it applied, it would prevent his employment with the head contractor, Schenker. One of the important points in this case was Section 4 of the Restraint of Trade Act in New South Wales. This section gives the court the power to read down the restraint of trade to what the court considers reasonable. In some ways, on some authorities, it's said not to alter the common law to any great extent. However, it's an important factor in the dealing of restraint of trade in New South Wales. The court was very concerned in this case to protect the legitimate interest of Quantum in protecting its know-how and its systems, because Schenker had indicated an ability and a willingness to try and substitute and develop its own systems to replace Quantum in the short to medium term. So there was an active issue as to whether or not Schenker was going to acquire unfairly the skills of the employee in question. The court looked at the role of the employee in question and found that he did have a substantial insight into the business of Quantum and did supervise a lot of people reporting on important aspects of the services that Quantum had developed and was providing. Accordingly, the court was concerned that if they allowed the employee to transfer, the position would be irretrievably lost against a final hearing of the matter as to whether or not the restraint was upheld. It's important to realise at this point that the court was only interested in an interim situation. It was asked for an interim injunction ahead of the main resolution of the matter, which would take some months. The court, when looking at an interim injunction, considers a couple of key factors. One is whether there is a good arguable case that the plaintiff will win. Obviously, if he has a hopeless case, he shouldn't get the benefit of an injunction that might operate for 1 to 6 months. In this case, they found he did have an arguable case that the restraint should operate. They next consider the factor of the balance of convenience. The court is reluctant to give an injunction where to do so will be more inconvenient to the person injuncted and prevented from doing than the benefit given to the person with the benefit of the injunction. In this case, after a careful consideration of the various factors, the court decided that an injunction should issue. In that, they weighed up carefully two interesting offers by each of Quantum and Schenker. Schenker offered to continue his employment but at another location, and therefore to exclude the possibility perhaps that there would be some transfer of his private knowledge into their system. Correspondingly, Quantum offered to employ the employee on the same terms and conditions at a different location that it operated at, in order that the employee wouldn't be unduly inconvenienced by the injunction, and in order that they would be protected from the transfer of know-how and expertise. In the end, the judge went with the idea that the employee could continue his employment with Quantum and made the injunction conditional upon Quantum keeping that offer open and acting consistently with it. The solution devised by the court in this case demonstrates the court's concern to achieve an equitable or just result. They're concerned that they not unduly have restraint of trade provisions broken, but on the other hand, they're concerned that they not operate to the inconvenience and permanent damage of the employee. And the court took into account that he did have family dependent on him and that he had a need to ensure that his salary came in every week to maintain that family. So the court was concerned to go into the detail and find out whether or not an injunction should issue. In that case, the employer achieved much of the purpose of the injunction, of the final remedy, by the injunction, because the injunction prevented for 1 to 3 months the employee being employed by anyone else, and accordingly the immediacy of his knowledge and his confidential information transfer will be minimised, if not substantially reduced. The court also considered that, but at the balance, decided the balance of convenience was in maintaining the status quo with the employee still employed by Quantum. The case demonstrates that in between two companies, non-poaching agreements may well work if properly drawn, reasonably based and carefully administered. They represent a prudent and practical protection that anyone in a joint venture should secure. Otherwise, one's chief executive can be attracted by an offer too good to refuse, and the business consequences are very substantial. The next case I'd like to consider is the case of Isaac and Dargon Financial, which is a case that was concerned when Isaac was engaged by Dargon to be a sub-originator of loans in the domestic housing market. Fundamentally, Dargon was to assist with obtaining business and with transacting that business by working with Dargon to arrange loans. After the parties had worked for a substantial time, Isaac decided to go out on his own and compete in much the same area. The question was, did a restraint bind him? The restraint was fairly wide and did prevent him on its face from doing a wide range of business. At first instance, Mr. Justice Sakar found that the restraint was reasonable and he upheld it, and he issued a permanent injunction against Dargon operating with the basis of the client list and other information he extracted from the business before he left. The case was appealed to the Appeal Court in New South Wales, and they considered it again. What I think was the interesting factor in this case is they accepted that he was an independent contractor and therefore had his own business that he was running as a sub-business to the business of Dargon. That interesting concept led on to the fact that in large part for many customers they were a shared client. That is, that Isaac had an interest in promoting his own view in the relationship, and so did Dargon. Accordingly, on appeal, the decision of Mr. Justice Sakar was reversed as to the first order, which had the permanent injunction, and continued in respect of a more limited time period. Accordingly, the courts had tried to address the issue from both parties' perspective and develop a reasonable solution to the situation. Interestingly, the courts touched on the issue of franchises, where a franchise has his own business operated within the constraints of the franchisor's franchise system. Accordingly, at the time that the franchise is terminated for any reason, whether or not the franchisee is restrained in his future trading will be an interesting aspect. And again, it is to be expected that those obligations would not only be judged against the franchise code, but also judged about their reasonableness and the effect they have on the public in limiting competition. The court's attitude to looking carefully at the roles of the two parties and then trying to establish what was reasonable both between those two parties and from a public's perspective was interesting. Again, the degree of proof, the degree of examination of the roles and responsibilities was probably more in detail than either of the parties had considered at the time they made the contract. But it shows again that restraints of trade do work if they're properly drawn, and if the court is prepared to consider that they are either reasonable on their face or alternatively can be restricted to a reasonable operation in all the circumstances. So it's important where many in the construction industry are employed as independent contractors to do project management or site management or design management, procurement management, that the employer and employee have a clear understanding as to the extent of post-employment restraint there is on the employee. Again, that will depend on the relationship the employee has with the customers, but it will also depend on the extent to which the restraining clause actually bites on the future conduct of the employee. It's important standing back from these cases to see that the court still has difficulty in coming to terms with the reality of modern commerce. The reality is most of these cases have been cases which in the 1800s would have been between an employer who had a premises and a business presence because of that premises, and the passing trade that continued past his door. His impact of an employee's alternative competition was pretty limited. However, these days, where an employee can set up a website overnight, can make a splash on social media during the next day and be fully functional within a week, has more issues for the court to grapple with. As of yet, the cases are still emerging, but it will be a lively topic for debate as one goes into the future as to who really owns your Facebook page, who really controls your Twitter account, and to what extent the ongoing representation of the employee is in breach of a restraint of trade clause. In order to draw a restraint of trade clause, consider a variety of circumstances. One is whether it's reasonable. One in length. A restraint for 20 years is by definition unreasonable in most people's eyes. A restraint for 3 months might be quite reasonable. It'll depend on the roles that people have, it'll depend on the business and sensitivity to the employee's activities, but you should be careful to be able to justify the length. The width of the clause, what activities does it restrain? And it's important to consider restraining only those activities which make a real impact. If one restrains all activities, and restrains all clients, then the situation is it's likely to be overturned. The other aspect is that if the clause is clear and simple in its impact, then it's more likely to be favourably regarded rather than something which might have been unclear to the parties at the time they signed it. The other aspect is, if it is important, if the person that you're appointing has a key role in your business, you need to be very careful about getting commercial and legal advice as to the type of clause you should draw and the type of arrangement you should sit it out with the ex-employee. One aspect is whether you have one agreement or two, and whether or not a separate consideration is provided for the restraint of trade. They're all important, and they're all important in terms of their impact on your business operations, because your business operations should be structured so that you don't have people in positions where they acquire information which would be invaluable to your competitors and which might not be able to be restrained by a restraint clause. So I encourage you all to look at the restraint clauses that you have or are about to have in your business, and make sure that, as far as possible, they give you some reasonable commercial protection from a legal perspective.